Hi everyone, I'm Julia Walker, a North Carolina estate planning attorney, here to help you understand why it is important to plan for your life and legacy. Today is all about estate planning and beneficiary designations. Estate planning and beneficiary designations go hand in hand. In order to ensure your goals are accomplished, your estate plan requires a conversation about your assets and who is named on your beneficiary designations. That's because some of your most valuable assets, such as life insurance policies, 401ks, and IRAs, often transfer best with beneficiary designations that allow you to name the person, persons, or entities you'd like to inherit the asset upon your passing. Those named on beneficiary designations receive the assets directly from the company or organization. So some of you may now be thinking that beneficiary designations will avoid probate, right? Ready for the go-to legal answer? It depends. Beneficiary designations can avoid probate, but you need to be very careful. Let's go over some examples as to why. 1. If you fail to name a beneficiary or you name your estate as a beneficiary, those assets will go through probate. You should have at least one primary beneficiary and at least one contingent beneficiary named. 2. If you've not kept your beneficiary designations up to date, such as if you have an ex-spouse named, then those assets will go to that ex-spouse. Even if you're remarried, your current spouse would not receive any of those proceeds unless he or she goes to court to fight for them. You should review your beneficiary designations and update them upon events like marriage, divorce, births, and deaths. 3. If you name an individual with special needs as a beneficiary, then it could disqualify that individual from receiving those much-needed governmental benefits. You should create a special needs trust to receive the proceeds to be managed by a chosen trustee that should distribute proceeds without affecting the individual's benefit eligibility. 4. If you name a minor child as a beneficiary, then a court-appointed guardian will have to be appointed to manage the funds for the child until he or she is 18 years old, and at which time those proceeds would be distributed outright to him or her without any further restrictions, guidelines, or guidance. You should set up a trust to receive proceeds for minor children and have a chosen trustee manage those funds for your child. And 5, if you name an individual to handle the funds for a child, then you have no control over what that individual will actually do with the funds upon receiving them. He or she could spend the money on themselves and your child could never receive anything. Or if that individual dies without properly setting up a plan to get those assets to your child, then those funds would go to that person's family instead. It's better to set up a trust to receive proceeds for your children. You need to be cautious with beneficiary designations. They can be a great tool if done correctly, but as you can see from just a couple examples, they can go terribly wrong, so you need to be careful. Or, better yet, work with an estate planning attorney who can give you guidance on how to take full advantage of beneficiary designations. A little bit longer of a video today, but it's very important information. I hope you liked this video and found it helpful. Please share with anyone you think needs to hear it. Again, I'm Julia Walker, a North Carolina estate planning attorney, here to help you understand why it is important to plan for your life and legacy. Have a great day.